In the United States, the foundation of our freedom lies in the Constitution, and the first 10 amendments, known as the Bill of Rights, define our most basic and well-established liberties. But when government officials, police officers, prosecutors, or judges abuse their power to violate these rights, it's not just misconduct. It's a federal crime under Title 18, United States Code, Section 242. Deprivation of rights under color of law. This law makes it illegal for anyone acting under color of law, meaning under the authority of state or federal government, to willfully deprive another person of rights protected by the U.S. Constitution or federal statutes. Under color of law simply means using the power of your official position, even if what you're doing isn't lawful. The rights protected under this law include, at the very least, the Bill of Rights. The First Amendment, guaranteeing freedom of speech, religion, press, assembly, and the right to petition your government. The Fourth Amendment, protecting you from unlawful searches and seizures without a warrant or probable cause. The Fifth Amendment, ensuring due process and protecting against self-incrimination and double jeopardy. The Sixth Amendment, guaranteeing the right to a fair and speedy trial, including your right to be present at every critical stage of your court hearings and trial. The Eighth Amendment, protecting you from excessive bail and cruel or unusual punishment. And the 14th Amendment, applying those same protections to state and local governments through due process and equal protection. These rights are not optional. They are the bedrock of American liberty. When an officer arrests someone for their speech, when a judge denies due process by holding hearings and trials in the absence of the defendant, or when someone is searched without a warrant, those are not just violations of civil rights, they are criminal acts under federal law. Under 18 U.S.C. 242, those acts are punishable by imprisonment, and in severe cases, up to life in prison or even death if the violation results in death or involves serious harm. But accountability doesn't stop there. When any government official becomes aware that a deprivation of rights has occurred, they are legally bound to report it to federal authorities. Failing to report such criminal activity isn't just unethical, it's complicity. A government official who knowingly conceals or ignores a violation of constitutional rights becomes part of the same criminal act under federal law. In other words, silence is not an option when liberty is at stake. For decades, many officials were shielded by a legal doctrine known as qualified immunity, which made it difficult for victims to hold them accountable unless an identical case had already been ruled unconstitutional. But times are changing. States like Colorado, New Mexico, Connecticut, and in New York City have passed laws limiting or abolishing qualified immunity altogether, allowing citizens to sue government officials directly when their rights are violated. In Colorado, for example, the Enhanced Law Enforcement Integrity Act ended qualified immunity for state civil rights claims, ensuring that no badge, gavel, robe, or title can shield someone from accountability for violating the Constitution. To summarize, the United States Code, Section 242, criminalizes any willful deprivation of rights under color of law. The Bill of Rights guarantees the freedoms that define who we are: speech, due process, trial rights, and protection from unlawful searches. Every official who becomes aware of such violations must report them, or they become complicit. And states across the nation are finally restoring accountability by dismantling qualified immunity, ensuring that government power serves the people, not the other way around. Freedom only lives when it's defended. Know your rights, stand up for them, and remember, no one acting under the color of law is above the law itself.